the way that people tend to view it is that because they keep their data so separate, they take the view, and I think I share this view, that they're both independent data controllers rather than joint controllers. And then you look at the intersection of your audiences, you find out, for example, you have 1 million customers in common, but you don't know who those 1 million customers are. Pretty much everybody is comfortable at that point on relying on legitimate interest. And I don't think that's controversial. Moving on to looking at specific IDs, that is when we tend to see people thinking that they do need consent.
Hello everyone, I am Sergio Maldonado and this is Masters of Privacy, a set of interviews covering the intersection of marketing, data, privacy and technology with a clear goal in mind, which is redefining the relationship between people, brands and media around transparency and control. Which is to say, we're aiming for real customer centricity, or if you will, human centricity. We regularly talk to DPOs, CMOs, CDOs and whoever else we find interesting and able to share valuable insights. So we hope you like it. Please do reach out if you have any ideas on future topics or speakers. We have Nicola Newitt here today, and she is a UK qualified lawyer who trained in private practice and worked at Slaughter & May before moving in-house to start her privacy career in Bupa's international health insurance business. She is now Senior Privacy and Product Counsel at InfoSum, which is a well-known data cleanroom. Now, we're used to discussing cleanrooms from a marketing perspective, and we listen to the use cases like analytics, performance measurement, or activation. But we mostly hear the overriding argument from marketers or sales teams that they are privacy preserving. But a data cleanroom could take different shapes, and some of them may even be the opposite of privacy by design or GDPR compliant. So we are going to dive deeper with Nicola into the key questions that advertisers, publishers, retailers, or rather the DPOs need to ponder when they audit different platforms or review the DPAs, data processing agreements, on offer. For example, who's the controller and who's the processor? Do we have a joint controllership? When, for instance, a publisher or retailer partner with a consumer brand? Which legal basis do we rely on for each of its three main use cases? Can different options at data activation level change our legal approach or safeguards? How does an independent data cleanroom compare to a walled garden cleanroom from a privacy point of view? And more. Okay, some housekeeping now quickly. We'll be hosting a couple of low-key live events if you happen to be around. One is here in London on March 23rd, and that's a Thursday, and another one in New York on the 30th. We're counting on a few past guests of the show and hoping to get a live recording on tape, as well as enjoying a few drinks. You can find out more and register for either one on the meetup.com links provided in our social feeds. And now, finally, our chat with Nicola Newitt. Nicola, thank you for joining me.
Thanks for having me, Sergio. Great to be here.
I was really eager to do this. I think some of the people that listen to us understand the idea very well because they come from marketing. They've suffered the whole, end of cookies, privacy concerns. But others come from the law. We've got plenty of DPOs as well, listening and commenting. And the very burning question is, to get started, who is the controller? So when you've got a data clean room, perhaps you want to introduce it in your own words. But my first question will be that, who is the controller and who's the processor?
Okay, yeah, good question. I think I probably should start by giving a brief intro of what a data clean room is, because I think it's clear, as you say, if you're in the retail industry, if you're in media, you probably know what a data clean room is. Although having said that, there are different kinds of data clean rooms out there, but the way I would describe it at a high level is a data collaboration platform. And that's definitely what InfoSum does. It's a place that parties can come, send their data, upload their data, transfer their data, whichever terminology you want to use, and interact with other parties on that platform. So it's all about data collaboration. That's really what it comes down to.
Yeah.
And then your question, getting into the meat of the issue, who's the data controller? Who's the data processor? I think, again, that depends slightly on how the data clean room works. But within InfoSum, for sure, we're very clear that the client of InfoSum, so whoever is the person uploading the personal data, whether that's about your customer base, whether it's about your list of prospects, your first party data that you're uploading to InfoSum platform, you are the controller of that data. So the user of the data clean room is the data controller. The data processor, in our case, is the party providing the data clean room. So InfoSum, in our case, is the data processor. And it's quite a clear distinction here, because it's the data controller, the client, who makes all of the decisions, sets the purpose and sets the means of the processing, decides what data they want to upload, decides what they want to do with it, decide who they want to work with, decide when they want to delete the data, etc., etc. So in that case, the person, the user, the client of the data clean room is the controller. The provider, in our case, InfoSum, is the data processor.
It makes all the sense. Thank you. And so then you've got this concept, which is the bunker, where this data controller would bring their data, as you said, for example, first party data, for instance, email addresses and some properties about their customers. If they want to collaborate with another party, let's say an advertiser and a publisher want to work together, I understand, but please correct me, that they both need a bunker, and that then there is a possibility that they could be joint controllers. But I guess that's not the most common scenario. What's your perspective on that collaboration?
Yeah, interesting question. So definitely the way that InfoSum works is you need your separate bunker, which is basically a data storage location. And the data controller uploading their first party data has their own bunker, and their bunker is always kept completely separate from anybody else's bunker. So there's no mixing of data, there's no access to the other party's data. It doesn't work in that way. And your question, or maybe your point of view about joint controllers, is an interesting one. And actually, I don't think it's a view that I share. And it's not something that I've seen any of our customers take the view on either. The way that people tend to view it is that because they keep their data so separate, they take the view, and I think I share this view, that they're both independent data controllers rather than joint controllers. And because of the way the InfoSum works, the processing that they conduct really is quite separate. They both decide, separate of each other, what data they're going to collect as their first party data. They have the relationship with the data subject. There's no overlap at that point. And then when they come to decide which data it is they're going to upload, again, that's a completely independent decision that they're making. So I think, my view is slightly different to yours there, Sergio.
It's good. No, it was more than a radical view. It was just a question, right? So, of course, it makes all the sense they're independent controllers. And I think it is aligned with the EDPB guidelines and, with like the fashion ID cases and these things we've had.
Yeah, exactly. And I think mostly those cases where there's been kind of a controversial decision about joint controllership, and there have been a few, as you refer to, fashion ID and a couple of others, where the market and I think a lot of participants were surprised and maybe scared that joint controllership was being found in places it might not be expected to be found. I think for me, part of the reason those decisions were made were really where there was a gap to be addressed in terms of the data processing. But I think of the way that data clean rooms work, and in particular InfoSum, is that all of the steps of the processing are very clear and very separate, and there's never going to be a gap in terms of a data subject. There's never any kind of issue that needs resolving there. It's always very clear, kind of at the upload stage, if you have an advertiser working with a publisher, they're both working separately on the platform. And when it comes to if you're using the platform for a targeted advertising, which I think we'll get onto later in this podcast, at that point, then the kind of the data processing moves to the publisher and completely independently that the publisher's coming out. So I think there's never a stage in the life cycle of the use of a data clean room where there's any overlap or a joint controllership situation occurs. I think you break it down into each individual stage, and there's never an overlap throughout that life cycle.
Good. Then we don't need an agreement. We need one with you, right? A data processing agreement, but we do not need anything between them. As per, there's no Article 26. So I guess that's another advantage to using you, or an open data clean room, if I can say, compared to walled garden, like Amazon or Ads Data Hub from Google.
Yeah, exactly.
Because after Fashion ID, the EDPB guidelines on social media campaigns that reflected this idea of the joint controllership for things like custom audiences and lookalikes, they involved that scenario. You upload your audience first-party data, CRM data, up into the platform, and then you want to target lookalikes. And according to the EDPB, and I guess stemming from Fashion ID, then there was a joint controllership with the social media platform. In this case, you are not playing both roles, but you're both the publisher. You determine even the manner in which data is hashed or encrypted, right? So I guess in your case, because you remain neutral, there's even a case to be made that it is safer from privacy point of view to use InfoSum, or rather than using Google or Facebook or Amazon, right?
Yeah, exactly. I think that's exactly right, because we are the data processor. We don't use the data at all for our own purposes. The data stays completely separate. You're not adding any information on your customers or your prospect list to kind of enrich profiles anywhere. The data's not being used to really, build up and add to identity graphs, for example. It stays completely separate. I'm convinced it is a much safer way of working. And to be honest, this is the whole reason, that the solution was created. It comes out of the problems that have been found in the AdTech industry by multiple regulators, including the ICO, but other European regulators as well. This has been built to solve all of those issues. So much greater transparency, less data sharing, very limited data transfers, etc.
Yes, pretty good. And like the original concern with DMPs, where they came up, because they were originally keeping that data to then keep onboarding and keep enriching audiences. So I guess that's why also they're
exactly. And then the problems obviously that have been found by the ICO and other regulators with the consents there kind of not being quite right in terms of data being transferred on and on and on, and were the data subjects ever aware all of the people that their data was going to be shared with? Can the transparency requirements be met? Probably not. So we think it's data clean room is a good solution for these problems.
Okay, so I'm sold so far. So
I'm doing a great job then.
yeah. So Nicola, so then let's go into that. Now that you said this legal basis, yes, let's try that. So in terms of guidance, consent would not be required, and legitimate interest. I'm quite obsessed, I have to say, and some people know.
You're not the only one. I think this is a key issue.
I'm so tired of consent. I'm so tired of consent, but everybody here knows I can't put up with it any longer. It's so if we could go around consent, not to abuse the system. In fact, to be more respectful, because it's something that goes with the flow and follows the reasonable expectations of customers. So the EDPB said, and I believe it is consistent with even like the e-commerce directive back in 2000, that if I've been buying from a supermarket chain or a retailer, whichever brand, so I'm a customer, and that data, my personal data, is then used subsequently to then offer me similar services, as it happens with email, right? In terms of, well, this is not spam because we bought before and it's similar services. That I could be, in theory, retargeted, remarketed with the same stuff elsewhere, and that could be covered by legitimate interest. But I wonder whether that's a common scenario, whether instead it's not the case, and there is a more common scenario where we are collaborating on these data sets to be able to see through each other's data sets without really seeing personal data, so that there is enhanced activation, addressability. And in that case, I understand we do need consent. How far do you go? Because you're a data processor in the end. So how far do you go? And I guess you can't even advise your customers, because then you could stop being a data processor. So what do you think about legal basis, consent versus legitimate interest? Or
well, it's a conversation we have all the time, because as you say, we're the data processor, we can't be giving out legal advice to our clients. However, of course, when clients haven't seen these kind of solutions, they like to talk these things through with us. So I've had this conversation with many different clients, and I'll talk you through kind of what I tend to see and also my own views as well. So what we tend to see is, through a data clean room and InfoSum in particular, there are two main kind of use cases. And what you can have is, I think, as you've referred to in your question, is initially just insights. So you kind of upload data, someone else uploads data, and then you look at the intersection of your audiences. You find out, for example, you have 1 million customers in common, but you don't know who those 1 million customers are. So what you're doing at that point is you're reviewing aggregated statistical data, which I think the EDP are quite clear is not even personal data. So I think at that point, although you've used personal data, of course, to get the insights, you've uploaded the personal data in the first place, all you're doing is analyzing your audience and a subset of your audience that overlaps with your collaborating party at an aggregated level. And I think all of the clients I've seen, pretty much everybody is comfortable at that point on relying on legitimate interest. And I don't think that's controversial. I think that's pretty clear that can be done on the basis of legitimate interest. Of course, as long as all of the other GDPR requirements are met, transparency, etc., you've let people know in your privacy notice. But as long as all those are satisfied, legitimate interest will suffice. When you then go on to the second use case of a data clean room, which is really then, and this is where clients tend to get the most value out of a data clean room, is then facilitating targeted advertising. So your example of a publisher and an advertiser saying to a publisher, hey, we've got these 500,000 customers overlapping. We'd like you to now target them with an ad campaign, please. And at that point, that's then when you move, and it can get a bit tricky at that point, because then obviously you're moving into targeted advertising, into profiling. And at that point, that's where we really get into the discussion with our clients about, okay, are we moving into territory where we need consent for this? I would say the majority of our clients are only comfortable using these. We call it through InfoSum, we call them activations, but what that really means is you're moving forward to targeted advertising. Most of our clients need consent to do this, or are of the view that they can't do this unless they have the consent of the individuals. And now my view is actually that I'm not convinced you will always need consent in these cases. And actually, there's been a helpful ruling very recently in the last week or so from the first tier tribunal in the UK, here in the UK, who've overturned a decision by the ICO in an Experian case. And in their judgment, they've been really clear, actually, that legitimate interest can be a basis for direct marketing purposes. I think what we've seen to date in the traditional AdTech ecosystem, which you've kind of referred to, data being sent around to CDPs, CMPs, DMPs, all the other parties that I couldn't even name in the traditional AdTech ecosystem, that kind of really intrusive data sharing and enrichment of profiles, which we've been talking about, that kind of intrusive direct marketing definitely would require consent, because it's not something that individuals would necessarily kind of expect to happen. It's very murky, it goes on behind the scenes, it's not really clear who's doing what. You can see in those cases, consent would be required. But if you're facilitating targeted advertising through a data clean room and through InfoSum, you are doing a limited data transfer, but it's really, really limited. So in our example of an advertiser and a publisher, when the advertiser is saying, okay, here are the 50,000 customers I would like you to go and target, the advertiser doesn't even know who those 50,000 customers are. So the only data transfer that ever takes place is the publisher learning, okay, these 50,000 people are of some interest to this advertiser. They don't have to know why, they don't have to find out anything else. So it's really, really limited. There's data minimization, there's a limited data transfer. It's not your traditional online digital advertising in that case. And so I'm actually of the view, and in particular, since this tribunal decision has come out in the UK, that actually such a limited and specific way of targeting individuals, when even the person targeting doesn't know who those individuals are, I think we will see more organizations and data controllers getting comfortable with using legitimate interest. And we do already have a couple, actually. There are some clients who already take the view that legitimate interest is an adequate legal basis for this kind of limited targeted advertising.
Good. I was going in that direction as well, because as you said, there's like the three use cases. And again, going from least intrusive, if you're going to do an analytics in aggregate in terms of finding insights or even some market research, like these kind of people tend to do this in the other space. And these are, again, correlations, large correlations. And you know, there's plenty of privacy preserving technologies that you also apply yourselves to add noise. You're always making sure that you cannot really get too small a sample, so that through correlations you could even get to individuals. So you really have these measures in place. And for analytics, I can see that case, and I can see very little risk. And as you said, I can totally see legitimate interest. There's another case which happens after activation, which is measurement. And plenty of people are so worried about knowing what works and what doesn't, that I can see they come to you as well for that. Oh, please let me understand what works better by looking at the data clean room, so we can collaborate with a space in which either conversion happened or attention happened. So, put together different sections in the funnel, different parts of the customer journey, and try to understand what happened. But we could also work with aggregates. In activation, which you were touching on now, I guess the closer what I do with a data clean room resembles the programmatic ecosystem, where you've got things like the TCF, the IAB's, Transparency and Consent Framework 2.0, which I know you can also apply, or you let your customers work with as a signal for consent. So if it resembles that environment, then there's the question that people have a reasonable expectation to be targeted by whoever sold them something. But that if I am one person with Boots, for example, with the loyalty card with pharmacists, and I am someone else with Sainsbury's or the Nectar card or Argos, which is the same, then I am happy with having a profile with each of these, but I never agreed for them to deduplicate me, right? For them to see through each other's database and then target me. So I guess there is no reasonable expectation. And so then I see the difference between options that you offer. And here comes my question at long last. I can see that in InfoSum, I could either push an audience, do a sort of export towards a CDP, a customer data platform, like for instance, ActionIQ or many out there you plug into. And from there, they're already connected with the media buying ecosystem, so I can, find addressability for that audience. Or I could use InfoSum to send it to a platform like Permutive, which is, in my understanding, but we don't have to go into the details, thinking segments, thinking, oh, people who like sports and, and health in media, these are the kind of people that are your customers. So go for that segment. You're not dealing with IDs. You're not translating this thing into cookies. So do people make that distinction? And so if you are going for granular addressability, then aiming for consent. But if you use a platform that allows you to activate at a higher level, then being able to rely on legitimate interest.
Yeah, that absolutely is a distinction that we've seen made. Yes, for sure. So, and the way that it works, as you said, kind of with InfoSum, if a company was to maybe sort of stop at the insights level where they're looking at aggregated data, they're looking at statistical data, they use that for media planning. And they could say at that point, okay, actually, we're looking for segments that are, I don't know, women in their 30s, for example, men in their 20s that are interested in buying cars. Yes, I think absolutely. If you're stopping at that kind of higher level and not drilling down into the specific individuals and an ID that relates to an individual, I think, yes, you definitely can. And then, as you say, moving on to looking at specific IDs, that is when we tend to see people thinking that they do need consent in those cases. But I think hopefully, as I've already identified, I do think we see some clients even saying, actually, even at an ID level, because of the way it's done, and because if you are working in a very different way to the traditional or programmatic ecosystem, as you referred to, which I think most customers that come to InfoSum are looking to do. That is, that's the point of using a data clean room. But yes, absolutely, I do think we do see a distinction really being made between kind of segment level and specific individuals and identifiable IDs.
Okay, so there's an opportunity for the data clean room use case as well, because in the RTB, in the real-time bidding programmatic ecosystem, when you gather consent, it's so dynamic that it's always going to be questioned. How can you call this thing free, valid consent, unambiguous consent, if the parties that you can show me are not the ones that are going to end up in the bid? Because it's so dynamic. In a data clean room scenario, I know very well who's going to be in the chain.
Yeah, I think that's definitely right. And absolutely, the RTB environment is very difficult to see how that consent can ever be relied on when you say the data ends up being shared with multiple parties, potentially unlimited number of parties having access to that data. Yeah, how do you ever get comfortable that the consent given up front? Because as we know, if a data controller is relying on consent, the data controller should have been named in that consent, and that is almost impossible, isn't it, in the traditional R2B real-time bidding situation. So I definitely think it's much easier if you're using a data clean room. That problem is, it's pretty much removed, to be honest, because what we see with the way that our data collaboration partners work, or the partners that are collaborating using the InfoSum platform, is that they rely on their own separate consents. Because remember, the way that our platform works is the reason people are using this platform is to identify common users. So it's not an advertiser sending a load of email addresses, for example, or other personal data to a publisher whom the publisher has no relationship with. What they're doing is they're identifying their overlapping audience. So they each have their own direct relationship with that individual. And what they do is if they are relying on consent, they collect their own consent from the individual. So actually, they're not using the same consent, they're using separate consent that's been gained separately from the same individual. So you take that problem away, actually, of people having to rely on, it's not a one consent upfront and then that's kind of passed on down the chain. It's that actually the parties involved are getting their own consent where consent is required.
Very good. Very clear. Yeah. So the Guardian is telling me that they will deduplicate my ID with Levi's. But then on the Levi's website, if I was ever there, then they are separately telling me. So I could agree to my data traveling in one direction, like I want Levi's to tell the Guardian that I buy jeans, but perhaps I don't want Levi's to know that I read sports. I don't know. It can get very complicated from
It
an
can
individual point of view.
it can get complicated.
I'm sure people don't think these things through so much as consumers. Nicola, thanks a lot. Any last tip? Anything that you think is worth saying for anyone who's really pondering whether to buy a data clean room, whether to talk to your team?
On the privacy side, I was even myself a little bit doubtful coming in to work at a data clean room, thinking, oh God, they're facilitating targeted advertising. Is it really going to be as GDPR compliant? Can it ever really be? But actually, when you drill down into the detail, you really do see that this kind of solution really takes away all of the problems, the privacy problems that you see in the traditional programmatic ecosystem. And as we know, especially as Europeans, it's just we're not going to be able to continue. Advertisers are not going to be able to continue in the same way for very much longer. It's getting more and more difficult, isn't it, for people to advertise in the traditional ways. So these kind of data clean rooms really are the future. They really will satisfy your legal and privacy teams. It's just a much, much safer way of doing things. So I really would, I'd really encourage people to look into using these kind of solutions. It's definitely the future.
Thank you, Nicola. I don't want to take a minute more of your time, but you said Europeans. And I have to say, InfoSum, you store data in Europe, do you?
We have options to store data in Europe. And so we can avoid the problem of a restricted international transfer for our European clients. Yes, and that again,
Many
I think is a
will
good.
ask that.
Yeah. Oh, absolutely.
These
It's on my privacy FAQs document. It's the one question we always get asked. Yeah, absolutely. And it's a relief for me to be able to say to clients, yes, and it's a relief for all of the clients to hear that, to know they don't have to go through all of the stress that comes with potentially transferring data out of the EU or the UK.
Nicola, thank you very much.
Thank you very much, Sergio. Great to talk to you.
Okay, that's all for today. And you will find some episode notes and links to our social channels on mastersofprivacy.com. Thank you for listening.